You're live.
Are live. And this is Senate Finance, February 9th, and we are going to start today kind of our walkthrough of bills that have been sent to us. We don't have too many at this point. We're going to walk through it. If anybody is viewing the same video I am, I assume you are, Senator McDonald is having some technical difficulties with his background screen. It seems to become a foreground screen. So just, there's strange things happening there with cows' heads and snow floating in and out. But he is with us. So we're going to start with S60. And Luke Martland is with us, Chief Counsel for the Office of the Legislative Counsel. This is a bill that I sponsored at the request of VAPSA, the public power, all the little munis that we had a whole lot of testimony with last week. They had some requests and I told them I'd get them in and we'd take some testimony and see what we thought about it. So, Luke, I'm going to turn it over to you and we'll see where it goes.
Thank you very much, Madam Chair, and good afternoon, everyone. Luke Martland, Director of Legislative Counsel. And as the Chair indicated, I'm here on S60 today, which is an act relating to allowing municipal and cooperative utilities to offer innovative rates and services. So I'll walk through the bill. And as always, please ask questions if anything I say is unclear. As background, Vermont has 17 different electric utilities. They're divided into three types. The first is an investor-owned utility. There's only one of those, Green Mountain Power. The second is municipal electric departments. There's 14 of those. And the third are the electric cooperatives, and there's two of those, Vermont Electric Co-op and Washington Electric Co-op. This bill concerns the second and third categories, the municipal and cooperative electric utilities. Now, all electric utilities are monopolies, they're regulated, and therefore they operate under certificates of public good from the PUC, from the Public Utility Commission, and their rates and policies are subject to oversight by the Department of Public Service and the PUC. The current statutes concerning rate setting are 30 VSA 218 and 30 VSA 225 through 227 primarily. And they make clear that the PUC has authority to oversee and set rates. And in 30 VSA 225 to 227, there's procedures set forth and the process to request rate changes and to have those rates reviewed and set. There also is 30 VSA 218 small d, and that's the law that this bill amends. 30 VSA 218 small d sets forth alternative regulation for electric and natural gas utilities. Subsection A of 30 VSA 218 d allows the PUC, upon the petition of a utility, of the Department of Public Service, or on its own initiative, and after an opportunity for a hearing, to approve alternative forms of regulation and rates for an electric utility. However, as to a municipal utility or an electric co-op, any alternative forms of regulation that are approved by the PUC have to also be approved by a majority of the voters of the municipality or the members of the cooperative. And you'll see as we go through the bill that this current law in subsection A also sets forth various criteria that the PUC will apply. And there's also additional criteria in subsections K and L that are specific to the municipal and electric co-ops. What this bill does, it amends 30 VSA 218D. It adds two new subsections, subsection N as in Nancy and subsection O as in Oscar. And you'll see that they have a similar format, but they do two different things. Subsection N is more general, and I'll go through that in a moment. and it allows a municipal electric utility or an electric co-op to change its rates for services separate from the existing ways to do that. And subsection O is more focused. It allows a municipal electric utility or a co-op to offer innovative rates and services that help achieve tier 3, which is fossil fuel reductions under the renewable energy standard, or to further the goals of the state's comprehensive energy plan. Now let's look at the actual bill. I'm not going to put it on the screen, but I'll walk through it as I always do. I'll read you the most important parts and I'll paraphrase or describe other parts of the bill. And once again, if anything's unclear or I'm going too fast, please interrupt and ask a question. So looking at the first page of the bill, and once again, we're amending 30 VSA.
Madam Chair,
Yes, Senator.
I apologize for not being on screen. I'm trying to understand what the problem that we're trying to solve with this legislation is. Maybe that's not the appropriate question at this time, but it seems sort of like an exercise when we don't know the problem we're trying to solve. And
Okay,
maybe
we may have
that's- yeah.
set this up incorrectly. The representatives of the utilities are coming directly after Luke. So why don't we let him walk through and then they'll tell us what this bill is doing for them and why, okay?
Okay, just thank you for hearing that, and thank you, Luke.
Okay,
Looking on page 1, once again, we're dealing with 30 VSA 218D, which is current law, and we're adding a new subsection N. And it states, notwithstanding subsection A, which we just talked about, and section 229 of this title, which is a different statute, and which basically prohibits a utility giving a special rate or a rebate or another kind of change or deviation from its rates. A municipal company formed under local charter under chapter 79 of this title and an electric cooperative formed under chapter 81 of this title shall be authorized to change their rates for service to their customers if the rate change is, and then there's 3 criteria. The first is A, apply to all customers equally. B, not more than 2% during any 12-month period. And flipping over to page 2, C, not more than 10% from the rates last approved by the commission, which refers to the Public Utility Commission. Now you'll notice it is talking about rate changes. So that could be either an increase or a decrease. And these are the 3 criteria that apply. Going to page 2. So we looked at the criteria that would apply to these potential rate changes. 2, which is on line 3 of page 2, is the procedure to be followed. And I'll read through this, and when we get to the next subsection, you'll see that it's substantially similar. 2 states that the municipal company or electric cooperative shall provide written notice of a rate change to the Department of Public Service and the Commission at least 45 days prior to implementing the rate change. Included with the submission shall be a rate analysis describing the rationale for the change. Unless an objection to the rate change is filed with the Commission within 45 days of the notice, or the Commission orders an investigation on its own motion, the municipal company or electric cooperative may implement the rate change. So they give notice, there's an opportunity for an objection to be filed, but if no objection is filed, and if the PUC does not order an investigation, that change can go into effect. Number 3 on line 11 on page 2 is a limitation. And it states that a municipal company or electric co-op shall not be eligible to use this subsection unless it has received approval for a rate change from the Commission after January 1st, 2021. Number 4 states, if a municipal company or an electric co-op's rate change is more than 10% from the rates last approved by the commission, the change shall not be approved pursuant to this subsection, and the change may only be approved pursuant to another section of law, which I summarized earlier. This is a little bit of boots and suspenders. So it's echoing what we talked about earlier, criteria C, that the change cannot be more than 10%. But what this does is make very clear that if the change is more than 10%, that change has to go through the normal rate setting processes. So once again, it may be a little bit of boots and suspenders, but it's making that point very clear.
Look,
And then
that's
number-
a cumulative, right? A cumulative 10%. So they couldn't go up 5% and 5% or 5% and 6%. It's a cumulative number.
That's actually a very good question because that's not explicit in the bill.
Okay. we'll
So
have to
that
check
is a legitimate interpretation, but that would be something to ask the other witnesses what their vision is, and that may be something to clarify. So that's a very good question. Thank you.
Madam Chair, may I ask a question? Luke, in paragraph 3, I've reread that a couple times, and what is that getting at? They can change their rates only if they've been approved? I thought this was they could change their rates without getting approved.
No, it means something a little different. So another good question. It means that you can't take advantage of this new pathway or vehicle unless you've already had a rate change approved through the existing processes after January 1st, 2021. So
Okay.
this doesn't kick in. You can't take advantage of this new law unless your utility already has had a rate change approved after January 1st, 2021.
So if they have not had a rate change in the last couple of years for whatever reason, they can't take advantage of this. It's only after they change their rates could they take advantage of this.
Exactly. So it doesn't look back. This is totally forward-looking, only forward-looking. So if this were to become law, it means that one of the municipal utilities, they couldn't use this mechanism unless they had had a rate change approved by the commission after January 1st, 2021. So it's only forward-looking.
Okay, but after January 1st, 2021, even if they go a couple of years without a rate change, they could still take advantage of it if they've had one after the January.
If they've had one after January 1st, 2021,
Okay.
yes.
Okay, thank
But
you.
let's, if this, just to be clear, and it's a good question. So this, say this goes into law sometime during the summer, and you have a utility that had a rate change approved in 2019, but nothing after that, and now it's 2025, they cannot use this vehicle. They cannot use this. They would have had to have a rate change approved in 2022 or 2023 or 2024. Is that clear?
Yeah, and that would go through the regular process.
Yes.
that
There's different regular processes, but yes.
different regular processes.
Okay,
Okay,
I've got Senator Bray and then Senator Brock.
Thanks. So maybe this is a witness who's proposing the change question, but the provision 3 that we just went over, is this sort of a prudent provision so that you want to ensure that someone's been through a relatively contemporary full rate making before they take advantage of this?
I think that's more of a policy question for some of the other witnesses. This bill is developed with input from the sponsor and stakeholders.
Okay.
So I think the rationale would be for another witness, perhaps.
Brock.
Does this mean that the municipality could go through a conventional rate change procedure today through the PSB or whatever, let's say that calls for a 4% rate increase? The commission only approves a 2% rate increase, and that goes into effect. Tomorrow, could the municipality come back under the new provisions and institute another 2% increase without going to anybody?
In theory, yes. But you'll remember that if there's an objection filed, it doesn't proceed. and the PUC on its own motion could order an investigation. So in answer to your question, in theory, yes. How likely that is, I'm not so sure.
Mhm.
Any other questions?
Let's keep walking through then, and then we'll,
Good. So we've covered the first new subsection, which is N. And as I indicated earlier, that's more general. And as we've just walked through, that allows a municipal utility or an electric co-op to change their rates outside of the existing processes to do that. Now let's turn to O. So O is more focused. The language begins on the top of page 3, and it states, notwithstanding subsections A and N, which is what we just looked at of this section, and section 229, which I summarized for you earlier, a municipal company and an electric cooperative shall be authorized to offer innovative rates or services to their customers as pilot projects without obtaining prior approval from the commission if the rate or service, A, and I'm now on line 7 on page 3, is designed to satisfy the requirements of subdivision 8005A3 of this title, and that is what we call tier 3 under the renewable energy standard. And that's called the energy transformation tier, and that incentivizes utilities to replace fossil fuels with distributed generation such as solar, or to develop projects that will reduce fossil fuel use. That's what we call tier 3. So this is saying that if the pilot project is designed to satisfy the requirements of tier 3 or to advance the goals of the state comprehensive energy plan, B, has a duration of 18 months or less, and C, shall not result in plant additions of more than 2% or an increase in the municipal company or cooperative's overall cost of service by more than 2%. So this sets forth what this pilot project needs to achieve and the limitations of time frame and other factors that restrict what this pilot project can attempt to do. 2, starting on line 15, is the procedure. And this language is quite similar to the subdivision 2 we looked at in the prior subsection. And it states in a similar manner that the municipal or electric co-op provides written notice to the Department of Public Service and the Commission at least 45 days prior to offering that rate or service. There's included in that submission the terms and conditions of the service, unless there's an objection to that, or the commission orders an investigation, the municipal utility or electric co-op can commence to offer that innovative rate and service to its customers. Number 3, which is on page 4, is basically a renewal provision. And it states that the municipal company or electric co-op shall provide written notice to the Department of Public Service and the Commission at least 45 days prior to the end of that 18-month duration period with any proposed modifications to the terms and conditions. And unless there's an objection or the commission orders an investigation on its own motion, the municipal company or electric co-op can continue to offer that innovative rate or service. So it was a pilot project for 18 months or less, and we went through the conditions. At the end of that term, if the utility wants to continue to offer that program or service, it can do so, and 3 sets forth a process for it to continue to do so. And number 4 grants the PUC rulemaking authority to implement this law. It's identical language to what we saw under subsection N. Are there any questions about this? Thank
Senator
you.
McDonald.
I've already asked the question, but apparently the
Okay,
answer is going to come later.
I think we'll get you your answer as we go forward. the utility, yeah, everybody's here. Melissa Bailey, I've got you on first. There you are.
Hi there, good afternoon.
Hi. And I think it might, good place to start is, why do you want this? Seems to be the base question. What problem are we solving?
Sure, yeah, thank you. Again, Melissa Bailey, Manager of Government and Member Relations, Vermont Public Power Supply Authority, representing the 11 municipal electric utilities. I do have some testimony, I do have some presentation materials. Would it work to share those?
Yes,
Okay, let me
I
just-
think. Committee, you'll just have to holler if you have a question, because I can't see you when she shares.
oops, sorry about that.
You need us to do something on this end?
Sorry, only take a second.
Something is coming. There we go. Or something is up.
Yeah.
There
Okay.
you go.
There we go. Thank you. Sorry about that. So sure, Melissa Bailey here to talk about S60 and why it's the provisions are important to the municipal electric utilities. I'm testifying on behalf of the 11 BEPSA members. I've also been told by Burlington Electric Department and Washington Electric Cooperative that they are supportive of the bill as well. And I'll try to be responsive to some of the questions that have already come up from the committee during Mr. Martlin's overview of S60. Initially, what is the problem we're trying to solve? Essentially, why do we want this? I think the long and the short of it is that we're looking to ease the cost and administrative burden of traditional rate making to allow the smaller utilities in the state to be responsive to industry changes and also implement minor rate adjustments in a way that doesn't impose undue costs on their customers. So again, I represent 11 electric utilities in Vermont. In aggregate, they serve around 30,000 customers and are scattered geographically around the state. Really briefly, VEPSA itself was established as a joint action agency and an instrumentality of the state in 1979 with the intent of maintaining local control of electric utilities while allowing them to achieve economies of scale. We're overseen by a board of directors comprised of one director from each of the utilities that we serve, those local communities. VEPSA provides a series of services to our members. I won't cover those specifically right now because I want to make sure we can focus on the actual bill language that's in front of the committee. As Legislative Council described, the energy electric utility landscape in Vermont is made up of 3 different types of electric utilities. The only investor-owned utility being Green Mountain Power, serving a little more than 3/4 of the state, and then the 2 cooperative utilities being Vermont Electric Co-op and Washington Electric Co-op. There are in aggregate 14 municipal electric utilities, 11 which are members of VEPSA. Speaking specifically about the public power utilities, the municipal utilities, our utilities are nonprofit and publicly owned. Both VEPSA and the members operate on a nonprofit basis, and any rate of return would flow back to customers for these locally owned utilities. Essentially, any revenue collected in excess of expenses stays with the customers. Our municipal utilities are overseen by elected or appointed local governing bodies. That's either a select board or an electric commission within the community. And their decision-making is transparent. Meetings are public and held in accordance with open meeting laws. Our financials and books are also open and publicly available. And as Mr. Martland also noted, we are fully regulated by the Public Utility Commission and the Department of Public Service. I note that because it is somewhat unusual across the country that municipal utilities be fully regulated by the state. There are only a handful of states in the country where that is the case. So it's a bit of an anomaly. Diving into S60, again, there are 2 distinct provisions of the bill. They're separate and unique. The one EPSA is advocating strongly for is the ability to implement minor rate adjustments without a full-blown rate proceeding. And the parameters on that, essentially how we would define minor rate adjustment would be up to 2% annually and 10% cumulatively. I know there was a question about the language on that provision specifically. The bill language does limit any rate change. Again, it could be an increase or a decrease to 2% in a 12-month period. And it can, the rate increases cumulatively can't exceed 10% from the last rate approved by the Public Utility Commission. So that's kind of the boundaries or the bands around these rate adjustments. And again, we see this as a way to allow municipals and co-ops to absorb kind of typical cost drivers. The 2% is essentially tied to reflect inflationary increases. So increases in labor or other costs that a utility might incur.
Melissa, what do you have to go through now to do a 2%, basically a COLA increase? What are we replacing?
Yeah, so I think the process isn't that different depending on the magnitude of the rate increase. So there's a need to develop testimony and spreadsheets and documentation. Essentially, and I'm not involved intimately in rate making, but my understanding is you need to kind of forecast all of your costs and compare those to a previous year and justify a need to collect additional revenue. The process can drag out several months, and there is the cost. There's the cost in terms of the labor and the time spent on the rate case, and then there's also the opportunity cost of what utility staff are not doing with that time.
Madam Chair, Madam Chair, where does this thing start? Presumably someone in the municipal organization or the co-op has an idea that we in this co-op have to do something. Where must that individual or those groups of people go first?
So if I'm understanding correctly, the utility staff would essentially develop a proposal and file that with the Department of Public Service 45 days.
They don't have to consult their superiors. They don't have to consult the board of directors of the co-op. They don't have to consult the select board. They can just go straight ahead and file it.
Oh, I see. I'm sorry. I thought you were speaking about in the statewide regulatory process.
No, I'm trying to understand the process from its beginning through its various steps.
Okay, Senator McDonald, are you trying to do the process as it exists now?
Yeah.
Okay, so I think, Melissa, that's what you were doing. Just take theoretical Muni number 1.
Mhm.
They've just signed a new labor contract with a 2% increase.
So they would know, VEPSA acts as that, does the rate making for our member utilities. But if
Okay,
if it came to staff's attention that costs were essentially projected to exceed revenue, we would go to the municipal and let them know that we thought a rate case was necessary. My understanding is that those do need local approval currently, and they would continue to need local approval by the local governing board of the utility under this provision.
okay.
So the local governing board would have approved and signed off on the increase in pay for the utility workers. That's where it would start. And is that, or we assume that's already happened?
My understanding is that the local approval would need to happen. I'm not entirely clear on the timing. I can consult with my rate person in terms of whether the state process is happening in parallel or whether the local process needs to happen first.
Okay, so that's something we need to figure out is what is, and perhaps some of the other witnesses can help us, but what is the local process? I was just under the assumption that, especially with Immuni, rates would need to be approved by somebody at the local level.
They certainly do need to be approved by either the electric commission or the board of directors.
Okay,
I can certainly get clarification. I believe that that would happen before the rate case was filed with the state, but I need to confirm that. I don't want to
okay.
mislead the committee on that piece.
Senator Bray has a question. Senator Bray, you're muted.
Thank you. I have a question about the first bullet. So there's a 2% annual cap and 10% cumulatively without a full case. Now, does that mean that there might be a series of these 2% and then 2 years later, 2%? And then finally, when you cross the 10% threshold compared to when you did your very first such rate increase without a full case, that triggers a full case again? Is that the idea there?
That's the intent, yes.
Okay. And might you ever pass one of these things that had 10% built into it altogether? Like you say, well, we're going to do 2% every other year, 10 years, 10 years in total, and you would just spell it out. I mean, you know what I mean? Like, can you put all the requests as like a series of rate increases? We need a bump in 23, 25, 27, and 29. Is that allowed in this, or you're just setting guardrails for when you must return to a full case?
Not entirely sure that I'm understanding the question, but I think the answer to your question is that yes, you could essentially increase rates 1% each year up to the 10% cumulatively, and then there would need to be a full-blown rate case
Okay,
once
thank
the
you.
10% was
Yeah.
reached. Just for context, utilities, at least the smaller utilities, do tend to delay rate cases and put off rate proceedings. More than half of the state's utilities have not been in for a rate case since 2010. So rate cases are not, they're not commonplace for these municipals. And that's part of what we're trying to address is getting essentially more frequent rate increases that are not as large.
Okay, Senator Hardy has a question.
Thank you, Madam Chair. Melissa, in the current process, I'm assuming when you go in for a rate change, there's some kind of process of public comment or the ability of the public to weigh in on whether or not they think the rate increase is okay or reasonable. Would there be any kind of public input in this new process that would allow ratepayers to weigh in?
Yeah, thanks for the question. So the local process would remain completely the same. So when the municipality that owns the utility was considering a rate increase, that would be noticed through public meetings, and that's kind of the avenue for public participation. The current, I believe the PUC process also requires notice to customers as well. And our thinking on that was that would be embedded in the rules and procedures that the Public Utility Commission puts in place to enact the statute if it passes.
Okay, thank you.
Madam Chair, could I ask?
Yes, I cannot see you, Senator. Yes.
Melissa, is there any COLA or anything built into the current system? Or if a utility wants a 0.5% increase, it's got to do the same process as if it wants a 6% increase?
Right. There's no mechanism for the municipals and co-ops to do any kind of adjustment outside of the typical rate making process. I think it would be fair to say that the process would be somewhat quicker and less administratively burdensome if it was a very small and straightforward increase. But in terms of the actual process, there's no difference between a 12% rate increase and a 0.5% COLA, as you mentioned.
And thank you. And right now, any increase sets off the entire process. There's no there's nothing akin to what we're talking about here, where just a minimal increase is standard form versus a full-blown rate case.
That's true. And Mr. Martland did talk about the provisions in statute that address alternative regulations. So currently Green Mountain Power operates under an alternative regulation plan with the state that does have some mechanisms for minor cost adjustments. I think it's a fuel adjustment clause. So there is a slightly modified process for the state's investor-owned utility. The municipals and cooperatives have elected not to implement alternative regulation for a variety of reasons, because of the difference in structure and not being investor-owned utilities. There's no motivation for undertaking a profit sharing, essentially a profit sharing provision, which is what's embedded in Green Mountain Power's alternative regulation.
Okay. Senator Bray, if you're finished, Senator Pearson.
Okay. Thanks. And you were on bullet number 2 there, which I'm guessing applies more to tier 3. Is that correct? I was just thinking about actually GMP's already, where they can, within guidelines, they can just file notice and run something akin to a pilot. Is that the kind of flexibility you're aiming for in tier 3?
My understanding is that that is the intent of the kind of the second provision of S60. And just for clarity for the committee, that provision, the innovative rates and services provision of this bill, did come out of a bill that was introduced last session, I believe at the request of the Department of Public Service. So Riley Allen, who I know is scheduled to testify, may have added an added perspective on that, but our understanding is this is to allow municipals and co-ops to offer kind of more innovative and flexible rates to essentially try things out on a pilot basis without undergoing the full rate proceedings that we've been talking about in the interest of furthering the state's environmental and carbon goals, and specifically meeting the provisions of Tier 3 and complying with the Comprehensive Energy Plan.
Okay.
Senator Bray.
No, I'll wait for Mr. Allen. I just was a little unclear as to in what way is tier 3 controlled by going through a rate case.
Sure. So my understanding is rates could be a tier 3, essentially a service offered under tier 3. Tier 3 achieves fossil fuel reductions across, a variety of mechanisms. In my mind, you could decide to offer a rate as a tier 3 measure intended to offset fossil fuel. I can conceive of a time that you could offer a specialized rate for a customer that's switching from diesel to electricity, potentially. So I see it as essentially a new tool in the tier 3 toolbox to allow utilities to achieve the tier 3 requirements.
Okay. Could that include maybe a particularly attractive EV charging rate, or you have to do that as a separate tariff?
I believe that an EV charging rate would fall under the innovative rates and services, a rate offered to a specific subset of customers. So I think Mr. Martland made this clear, but the minor rate adjustments have to be applied across the board to all customers, all customer classes. And the innovative rates and services allows for specific rates to be offered to a subset of customers.
Okay, thank you.
Did that mean it doesn't have to be equal to all customers across all classes? That's what's being encouraged here.
The innovative rates and services may only be applicable to certain customers. For instance,
Drop the word innovative. Just get rid of it. Are co-ops permitted to offer different rates to different types of customers?
yes, I think currently that could be done under a full rate proceeding, a new tariff filing essentially. I think that what this bill kind of envisions is for, as Senator Bray, the example he threw out, electric vehicle drivers, we could have a rate specific for residential electric vehicle charging. It just simply wouldn't be applicable to the commercial class or the industrial class. It may only be available and applicable to a subset of customers, a specific rate class.
So, okay. Madam Chair, I'm not objecting to the proposal. I'm trying to understand it. And I'm assuming at this point that the rate change as just described would take place only after the co-ops or the municipalities, according to their own bylaws, had made the proposal to their customers and allowed an opportunity for hearings and amongst their customers. And after that would then move forward and propose the changes in this bill that some might call modest or innovative with the numerical limits as set forth. Is that correct?
That's, yes.
Thank you.
Okay. Have we got any more questions? I'm not hearing anyone, so Melissa, I think we can move on. Here we go.
This is the kind of the meat of the testimony here, the rationale for the bill. I think we've touched on a lot of these points already. But again, this is intended to facilitate innovation, allow the utilities to react more nimbly. Essentially, as the committee is aware, the energy sector is evolving rapidly. And some would argue that the regulatory processes have not kept pace. And this is allowing utilities, again, to be more nimble and responsive to industry changes, as well as to absorb kind of routine cost drivers, as we've discussed, inflationary and labor type costs. It would give the municipals and cooperatives the ability to respond quickly and be flexible in serving essentially the policy, overall policy goals of the state. And as we've talked about, it's intended to reduce the cost and administrative burden of the current process, which is, of course, for municipals and cooperatives borne directly by the ratepayers. All of those costs of regulators as well as utility staff time are passed on to ratepayers. And also in the interest of ratepayers, this would provide essentially a smoother rate path and promote rate stability, because we would be potentially minimizing larger rate increases that come more sporadically or after a longer period of time. So they could potentially absorb these smaller increases that may potentially come into play more quickly or more frequently. Again, part of the intent is containing costs for ratepayers and allowing utilities to focus their resources on more innovative projects and services to the customers. Finally, I'll note one challenge that motivated VEPSA to pursue this legislation was due to concerns raised by our rating agency. Moody's Financial Services did essentially note in their rating of VEPSA over the past couple of years that our rating was downgraded due to Vermont's regulatory environment. It's seen by investors as a risk that utilities don't have the ability to municipal utilities do not have the ability to set their own rates. It's seen as risky from an investor standpoint that they may not be able to essentially recover costs. And so the result of this is higher borrowing costs for the municipals and for VEPSA itself. So that's also one of the concerns that we're trying to address.
What is your rating? Your bond rating?
So I wrote it, so we would have, VEPSA itself would have been rated at AAA, and we were downgraded to a Baa1.
All right. I don't have the treasurer here, but I know that's not as good as a AAA.
That's
And
about.
yes, I think the state has had to make changes in its reserve funds in order to allay the concerns. But when that also then would add to rates. If your cost of borrowing is higher, then that is borne out in higher rates to pay that bond. So, okay.
That's right, and that's a concern. We have, BEPSA itself has about 20 million in outstanding bonds for a power plant that we own in Swanton, and of course, other needs to finance projects and borrow. So that is a concern that we've been trying to address.
Okay.
If there aren't questions on this one, I think I have just one more slide.
Not hearing or seeing any, so.
So we have been in contact with the regulatory bodies, the Public Utility Commission and the Department of Public Service, kind of since the summer when this concept began to materialize. There are several regulatory safeguards embedded in the legislation. The first was added after conversations with the Department of Public Service, this need to have a PUC, essentially what we're calling the traditional rate case after January 1st. To Senator Hardy's question earlier, there's no magic to January 1st, 2021, but the idea here was that there'd be a level setting, kind of a full review of the rates before these municipals and co-ops would be afforded the flexibility to adjust rates on their own. Of course, we remain fully regulated by the Department of Public Service and the PUC. So the bill itself calls for advance notice to those parties. Anytime a municipal or a co-op wanted to implement a rate adjustment or offer a pilot rate, we would need to notify the regulators 45 days in advance and give them the opportunity to raise any concerns. For the minor rate adjustments, we envision that would look something like an informational filing about what the cost drivers were that the utility was seeing and what the magnitude of the rate adjustment that was being projected or suggested was. The PUC retains and would, under this bill, have full authority to investigate rates at any time. None of that is changed through the bill. As we talked about, there's bandwidth around the magnitude of the rate increases that could be implemented, no more than 2% a year and no more than 10% cumulatively over a time period. And of course, the rate adjustments would still require the approval of the local governing body. And I apologize for not having a clearer answer to that question earlier. I did just receive confirmation that local approval happens before PUC, the PUC process, before we would even file with the commission. So sorry for any confusion that caused, but that is the current process, and that would stay in effect with this bill. So we see those safeguards as really important, essentially in keeping oversight of rates that the PUC and department have in statute, while also essentially addressing some of the concerns that municipals have about undergoing rate cases and easing some of that regulatory burden and some of the cost ratepayers are bearing due to the administrative proceeding.
Okay, Senator Hardy has a question.
Yeah, and this may be a question for when the PUC actually testifies, but I'll just throw it out there in case Melissa has a comment or anything. I'm surprised to learn, and I'm new to this area for sure, that most of your members haven't come in for a rate change for a decade. That seems like a really long time. And I guess I'm wondering, and like I said, maybe PUC has to answer this, like how burdensome is this process that you're going to wait 10 years to come in and do it? Is it really, really that bad?
I'm not sure what the PUC's perspective will be. I certainly won't speak for them. From the municipals, see it as something to be avoided when possible. I would say it's not unusual. It's not unique to the VEPSA members to go 10 years without a rate case. I think you'll find that across. I know Burlington hasn't been in for more than that. I think you'll find that across the co-ops as well. In terms of how bad it is, I have not been intimately involved with a rate case, but I do think that it's seen as burdensome, and there can potentially be, there can be litigation. There can be a lot of back and forth with the regulators. I do know, speaking for Swanton, one of our members, there was a rate case several years ago, and they said that the cost of the rate case essentially exceeded the added revenue that they would have gotten by implementing the rate in that 1 year. So it cost whatever the rate increase they were seeking, say it was 5%, the added revenue from a 5% increase, they spent more on the rate case itself.
Mhm.
There is a strong aversion to going through this process. It is seen as costly and time consuming.
Okay. And your members are mostly really tiny. The village of Johnson, for example, and presumably the ratepayers there can easily go to their select board and complain if they are not in favor of the rate change. I will just say I'm concerned about larger ones. I want to make sure that there's still public access and the ability for the public to easily weigh in on a rate change. So hopefully that can be discussed by other witnesses as well.
Okay. Senator McDonald.
I'm pretty much satisfied that, first I want to appreciate the witness starting from scratch and doing some sidebar communiques to answer a couple questions, and that has helped me understand what currently takes place before the changes that are proposed. The language in the bill also says if ratepayers are concerned, they may appeal to the PUC and say we have not been properly heard. Is there a number or a threshold for that? And or is that up to the PUC to decide once they hear from ratepayers?
So the bill doesn't specify a process for notifying ratepayers themselves. Our interpretation was that would fall under PUC rulemaking. The ratepayers, customers certainly have access to the Department of Public Service, the Consumer Affairs Division there, as well as directly to the PUC. So our understanding is that if there were concerns, they would either emerge through the local process, most likely, and if that for some reason didn't happen, they would be able to call the consumer advocates at the Department of Public Service. And I think my interpretation is that if issues like that arose, that would be the type of, that could potentially preclude the rate increase or adjustment from going into effect under the streamlined process, and it could lead to the more detailed process. Essentially, we're seeing two pathways. This is a potential for a streamlined process where there aren't a lot of concerns and where the potential rate adjustment is small, and then the more detailed process as a backstop.
Thank you for that answer, and it makes sense. So, Madam Chair, my question would be, what if the Board of Directors or of any of municipalities or co-ops who have seen electric rates go down because of innovative uses of batteries, because of solar power, because electricity simply isn't as expensive as it used to be. When Green Mountain Power consolidated with forget the name, CBPS, it was widely believed that they were going to save a lot of money, and they made a promise that they wouldn't raise rates for a long time. Many customers said, hey, if you're saving this money, why aren't you before the board lowering rates right now? Why do you get to sit on that, the efficiencies that have just passed? Why are you not obliged to go to the board and seek a rate decrease? That was the case 10, 15 years ago. And and it didn't happen. How do ratepayers and municipalities and co-ops who go to the board and say, why are you not offering reduced subsidizing batteries or electric vehicles in a way that would bring rates down? Why are you not doing so? How would they be heard if the boards ignored them in this case, under this bill?
Sure, there's, I would say that this bill would give the local governing body the ability to, again, implement a 2% reduction potentially. So this bill does allow for some more flexibility in that regard, without having to file with the PUC for a rate reduction, which again, I think would undergo the same scrutiny as a rate increase. So if the rate adjustment were minor, the local governing body could do that under the provisions of this bill, to the extent that customers requested that during the local process and were ignored, I think is kind of the scenario you're laying out. The avenue for recourse there is I see it as through the Department of Public Service and through the Public Utility Commission, who can currently and could still under this bill investigate rates at any time of any utility. So the PUC could open up any utilities rates for consideration at any time and look for whether there was justification to lower those rates. If the rates were not seen as just and reasonable at the department's request or on its own, the PUC can look into a utilities rates.
Madam Chair, I perhaps didn't answer the question. This is my last question. I thank you for your patience. If there's a group of people in co-op or municipalities who believe that a rate increase could be justified under the following conditions, and they go to the board of directors, et cetera, and say, you should be doing this for the following reason, and you should reduce our electric rates, and that group of people is ignored by the board, does that group of people have the opportunity to go to the PUC and say the board is not being responsive and is not lowering rates, is ignoring policies which would reduce our rates? Are they, under this statute, these changes, given an opportunity to have an equal say for rate decreases as they would for rate increases in the absence of a announced hearing for a rate decrease?
Yes, the bill treats rate increases and rate decreases kind of exactly the same. And I'm not sure if I'm not answering your question. I think the avenue for customers that are either unhappy about a rate increase or conversely unhappy that their utility is not seeking a rate decrease, I think the best avenue for that is through the Department of Public Service. The Consumer Affairs Division would hear that complaint, and I think that, or the customers could, I think, formally petition the Public Utility Commission to open up those rates to explore them.
Thank you, Madam Chair. Thank you for your patience.
Melissa,
Thank you, witness.
I'm trying to figure out what this would change. If I am unhappy because my utility, for whatever reason, hasn't done something, and right now I go to the local board and they say, yes, thank you very much, but we don't think so, and you don't win. When they go in for a rate change, I have to go through the formality. And I remember we did a lot of work, maybe 4 years ago, trying to make this process, which has traditionally been between the board's lawyers and the utilities lawyers. I assume that's why it gets expensive, because these are specialized lawyers. And we've been trying to make it easier for consumers who can't afford specialized lawyers to intervene. It sounds like under this, and I'll leave it to the PUC folks, that if they object to a rate increase, then they can file a complaint either with the Public Service Department or with the board, which is the process they go through now. If you lose at the local level, you would have to go through those next steps. Is that?
That's my understanding. There's no change to that public participation process.
This just says that if I'm going in, and basically it's non-controversial because, if no one's going to file an objection, I'm looking to 2% to cover a labor cost. It's going to save the utilities the money of hiring the specialized attorneys and witnesses if this is non-controversial. The minute it becomes controversial, somebody's going to file a request, or the utility commission can look at it and say, I don't know. We want to look at it. So, and I assume that the Department of Public Service could also request if they think there's something off here.
Right, the notice would go to the Department of Public Service and the Public Utility Commission after the local process was
Okay.
carried out. And
If I'm aggrieved, even if I'm only 2 people and the other 200 in the utility don't agree with me, I can still file that request as I can now.
I believe the provision in statute is that 5 affected
Affected? Okay.
5 affected ratepayers or 1 ratepayer that's affected, I think, to a significant magnitude or something.
Okay.
But that process would stay in effect,
It's the same as it is now.
right?
All right.
We're really seeing this as non-contentious adjustments. People are used to costs going up with inflation year to year, and we're seeing this as consistent.
My concern would be if you haven't gone in a decade, either you are highly inflated to start out, or you're swallowing things perhaps you shouldn't be, like wage increases or maintenance. But to go 10 years without a rate increase just in today's world, I am concerned about how you can do that unless you really do go in for the highest possible increase you can get and then just hold out for 10. It's not easy to get a rate increase at the local level.
Our
Okay.
members avoid raising that question to the extent they can, both in the interest of keeping costs low for ratepayers and in avoiding the process both at local and state level.
Okay, maybe we'll go on if there's no other questions for Melissa. We've got Riley Allen and.
I have one quick one.
Right, yeah.
Yeah, thanks. So we were talking about it as a risk, to ratepayers, like seeing a rate increase they might not like, and no one likes to see a rate increase. But aren't there, especially for the tier 3, the hold your ear, Senator McDonald, the innovative features in tier 3? My understanding was that part of what's utilities are after are ways of doing that work in such a way that, if you end up with beneficial electrification, you're growing load, so you're increasing volume, so you're taking some pressure off of rates. I mean, there is some of this flexibility could be helpful to customers who aren't even participating. Is that right? Or am I imagining on behalf of them?
I think in theory, the economic value of electrification is real. I would say we haven't quite realized it yet. We're still in early stages of electrification. And to that question and Senator Cummings' comment earlier, there are a lot of cost pressures and also cost reductions that can be felt at the electric utility level. So, to the question of why folks might not go in for 10 years, we have low fuel prices. We have potentially comparatively low wholesale energy prices right now as cost essentially depressors. And then we also have cost drivers and increasing distributed generation, net metering, things like that are driving costs up. So to some extent, those may offset. I think the long-term trajectory, Senator Bray is correct that we are going to see increased electric loads that have the potential to drive down costs for everybody. And this bill could allow for minor rate decreases year over year as a result, once we see those electric loads begin growing again. Essentially, we've been at stagnant loads for a long time. But once tier 3, the results of tier 3 essentially begin to materialize at a greater scale, I think that there's the potential for rate decreases as well that would benefit all ratepayers.
Okay, I'm gonna see if we can't move through because we're getting a little bit behind in our witness list, and I really don't want to cut into your break. So I'm gonna move on to Riley Allen.
Okay, I'll stop sharing. Thank you very much for the time.
Thank you, Melissa. Okay. There's Riley. Welcome.
Hi. So for the record, I'm Riley Allen. I'm a Deputy Commissioner of the Department of Public Service, and I'm here to testify on Senate Bill number 60. Hopefully I'll be quick. I want to say that the department, the second part of this related to innovative services is actually kind of a provision of a bill that we actually introduced last year, and then we've worked with the utilities to kind of refine it, and we fully embrace that. We think it's needed. We think that it's important for our utilities to have the flexibility to kind of trial services and kind of put things out, test their systems relative to some of the flexibility and functionality of their system relative to offering rate discounts for electric vehicles or other things. So we fully embrace that. We think Green Mountain Power has done a good job of demonstrating the value of pilots and innovative services. And I don't think there's any controversy there, but I'll pause there in case there are questions about that.
Any questions at this point? Okay.
Okay, so the first part, there is a, I won't call it controversy. I think in large part we're supportive of the kind of the direction that the VIPs and the utilities are pointing. We do have a reservation. We do have a proposed change. We couldn't come to agreement on that, but it really relates to the timeliness issue. We think that too much time has frankly passed. I think there's been like 6 municipal rate cases in the last 10 years out of our 16 utilities. So there's an awful lot of time that has passed with many of our systems. We think that it would be helpful if the bill had some provision that's kind of a character similar to that January 1st, 2021 provision that created a space of say 5 years to pass before, essentially the opportunity, the flexibility that's associated with a full rate case expires. So once rates have been essentially reviewed, a full rate case has occurred and reviewed, there is flexibility over a 5-year period, which we agree is appropriate. We notice that utilities do tend to wait until there's at least a 5% and often something in excess of 10% of an increase when they come in. Not so much the co-ops and not so much Green Mountain Power, but particularly with respect to the smaller municipal utilities, they tend to wait until they have to. That suggests to us that there's an accumulating problem or burden. There may be some deferral of certain costs, other ways to kind of work things out so they don't kind of have to face the challenge of going to the Public Utility Department or Public Service Department and the Public Utility Commission. And we think that we think it's kind of good regulatory practice, frankly, to come in periodically, get a clean bill of health, and then kind of enjoy the flexibility for some time following that. So we would propose that that subsection 3 be modified to provide an additional timeliness element in order to have and to avoid essentially the present circumstance of a large passage of time before utilities have come in for formal rate review.
Okay, so you would like, after they have this initial review,
Mhm.
that rather than a 10-year, they only have a 5-year?
Yeah, in fact, they could have, I mean, right now, the way I read it, they could have more than 10 years go by. There is no time
Well, yeah, if
limit.
they don't come in for a formal one for 3 years,
If
after
they-
that, they have 10 years.
I'm not aware of the 10-year provision. There's a 10% provision.
Okay, I thought there was a 10-year, but I may be wrong with that. Okay. So you would like a closed time frame.
I'd like a closed time frame. We're recommending 5 years. That's, I think, you know, I scanned last night, the last 18 years, and I estimate that it's about 4 years in between rate cases for the municipal utilities on average. There was a bunch between, say, 2003 and 2010, and then it's been pretty slow going since then. But we think that after 5 years, there's enough time that has transpired that it makes sense from our standpoint to, you know, not require, but rather kind of encourage them through the mechanisms that exist here, recognizing that there would be some regulatory flexibility that would follow.
Okay, Senator Hardy and then Senator Bray.
Thank you, Madam Chair. Mr. Allen, so what it sounds like you're suggesting is if you would like to see them come in more frequently so you can quote unquote look under the hood, or I can't remember the phrase you used, but something like that. But would that be required? Right now, they're not required to come in anytime. They can go 15 years without coming in, right? And so even if we were not to pass this bill, would you like to see requirements that they come in more frequently?
I'd like to see them encouraged to come in. I think, you know, I'm not asking to require anything, but we think that what is being provided for here is something that they would want and they would value, and you know, inserting kind of some mechanism to kind of facilitate and encourage they're coming forward and saying, you know, we've organized our documents, and I don't think the testimony is required, but I think that's good practice.
Okay.
If they would come forward and offer up something after a certain period of time, we think that that's appropriate and sensible, and it means that the rate case is really where the regulatory apparatus, you know, really kicks into gear. So we can kind of leverage our integrated resource plan commitments and other things when it comes to the rate case itself. And so having that tool available to start, you know, essentially addressing it. Usually when a rate case happens, it's not just a look at the rates. We're actually looking at all aspects of service. So it's an opportunity for us to, as you say, kind of look under the hood, consider their investment patterns, their tree clearing practices, their quality of service, reliability, other aspects of service at the same time.
Okay, and so I'm sorry, Madam Chair, just a quick follow-up. I mean, I asked Ms. Bailey this question too, but you know, noted that I wanted to hear what you had to say about how burdensome the process actually is to come in for a rate review. Because if they're avoiding it for so long and it's so burdensome, then that in and of itself is a problem. And if you want them to come back in after 5 years of getting this and go through a full rate review, that might actually not accomplish what they're trying to get here. So just curious your thoughts on the process and the.
Yeah,
And that
Well,
was my question, is the cost and what's involved.
sure. It's a fair question, and just as Ms. Bailey has difficulty kind of characterizing the burden on the commission and on the department, I have difficulty kind of characterizing the burden on the utilities themselves, but it is fundamentally spreadsheets. I mean, it's putting together the numbers, and it's looking forward on your capital plans. It's looking at your power costs. It's estimating power costs, looking at the impact on your operations from the rate change. It's or the cost of operations. It's looking at your accounts historically, and then forward on a forward basis over at least the next what we call the rate year, or the period in which the rates will go into effect. So at least from my standpoint, it's there is some number crunching there. The testimony portion becomes pretty important if you have a rate case. That is, if we actually go in and litigate the case, then the lawyers get involved. Then there's the legal expenses, and probably more focus on the back and forth as you go through the discovery process. But less, probably in the neighborhood of a quarter of these cases actually go to that stage. So you're really talking about filing a review of something. Good practice is to come in, talk to the department first, and see if there are any problems. Often we'll find just a simple math error, and then we'll ask that the matter be refiled. It can be refiled, and then we avoid the litigation altogether. So I guess I will acknowledge that if you go through, a contentious rate proceeding, that can get, pretty expensive, and for especially our IOUs, that can sometimes get into just a lot of money. On the smaller systems, they're a lot less contentious, and it's less of a burden. But it's I'd say 2/3 or 3/4 of the time, it's really just a matter of exchanging books, forecasts, and numbers, and coming to agreement on what it is. And it goes no further than that. It gets filed, and then it's up to the commission to decide what to do with it then. And more often than not, they follow our guidance on whether to investigate further.
Okay, Riley, listening to you, this is a benign process, and it doesn't have to be too expensive if everything gets worked out. So if it's such a benign process, why did the utilities avoid it? Like it is the most, because you have in-house counsel. This is what you do. I have a feeling, that a small muni doesn't have that. The risk that one disgruntled neighbor could throw this into 2 years of litigation is there. And I'm wondering, because if there is a way we could find a middle ground, something where you could have the surety of seeing where they are. I mean, putting off any rate increase for 10 years to me is concerning. That if there is some kind of a middle ground that wouldn't have to go all the way to a potential court hearing. I understand that, in other states, the state doesn't get involved. I also understand that there is risk when you have municipal utilities where people may or may not know anything about municipal power when they sit on the board, or power markets, or anything else, and trying to make sure that these essential services don't get themselves in any trouble. At the same time, I mean, this is like pulling teeth. It sounds like you avoid the dentist until the pain is so bad you can't put it off any longer. So just think about it.
Well, I mean, I think I've tried to reflect on that. I mean, we're not actually asking to require anything. That is, what we're trying to do is create a carrot. We're trying to recognize that coming in for, I'll use the word regulatory hygiene, but it's just kind of good health practices to come in. It provides, I think, a multitude of benefits. We're ratepayer focused. We're interested in their customers as they are. And what I'm trying to encourage is a dynamic that, encourages through the opportunity and the flexibility that would follow afterwards to come in, have your books ready, and have us review it periodically and be motivated to produce those. But in my mind, what we're proposing is actually the middle ground. It's not required. We're not asking to require anything. Everything that is essentially on the table is more than the utilities have now. And we just want there to be a timeliness element that goes beyond the initial threshold of January 1st, 2021.
Okay. Senator Bray, I've got you, and then I'm going to move along because we've got 8 minutes and 2 more witnesses. And we have only scheduled a 15-minute break, and I have a hard stop at 4 for joint fiscal. So you can go on when I'm gone, but I'd like to get us through this.
Quick question. Well, so I'm listening to all these dentistry metaphors. It sounds like for the utilities, they think it's a root canal, and you're trying to tell them it's just a cleaning. So maybe we could find something in between. For the kind of review that happens, on quality of service, et cetera, do all these are utilities either by tradition or regulation already tracking a lot of this stuff? So in other words, they're not doing a lot of homework to get ready for the rate case. It's actually sort of opening their books to you.
That's the way I view it. They are and should be keeping track of their quality of service, and they should have their books in order. There are probably some increments, the forecast of capital, but in my mind, that's something that they probably should be doing anyways. The forecast of power costs, a look ahead on power costs, they probably should have that in view anyways. I think, there's probably a level of effort that goes above that when you're presenting it to regulators and to your own board, because you want to, be able to defend, and you want to have multiple sets of eyes on these before you present it to others. So I won't pretend that there's not an extra effort. I think it's also just, frankly, the anxiety, it's the publicity, other factors kind of play into this as well.
Sure. The other quick question is, I just want to understand your proposal. So if the bill is written currently on January 1 of 21, you show up on the 2nd, you do a full rate case. So you sort of open a window to being in this flexible structure. And are you saying that what you would like to see is that window close within 5 years?
5 years of the last rate approval, yeah.
Right. And so then the motivation is, if you want that flexibility, you're going to need to return to a regular full rate case in order to reopen the window for yourself.
Exactly.
Got it. Thank you.
Okay, I'm going to move us along because we can have everybody back, and I'm hoping the utility representatives are listening to this, and I'm interested in their view as to what it takes to prepare a rate case. So we have Joan White from the Public Utility Commission. Welcome.
Thanks for the invitation to come testify. The commission's obviously very interested in this bill. I really just have a couple things to say. The first is we're generally supportive of this bill. In our view, it gives us a little bit more visibility into the books and the operations of the municipal utilities. They do tend to stay out for a long time, and then they come in with big rate increases, which can be a little shocking, I think, for their customer base. But also it gives us kind of a regular checkup into their finances. So yeah, supportive in general. The only other point that hasn't been brought up yet that I wanted to address was the governance structure in the municipal utilities. In many states, municipal utilities are not regulated by their Public Utility Commission. In Vermont, they are. And the reason for this is that there are many utilities that have the utility itself is run by the select board of a particular town. That's kind of the governing body, but the customers might be spread across several towns. So there are customers in that utility's jurisdiction or service territory who don't vote for the select board that's actually setting rates. So there was a history, this is like deep history now, like in the 70s and 80s, when you would have the select board, the rates in town for the select board that actually ran the utility would be lower than the rates for the non-voting kind of elsewhere. So that was how they got brought into our jurisdiction.
Good old days.
Yes, good old days. I want to be totally clear. That's not happening now. They're all the rates are the same all across the board. So that's how the Public Utility Commission got involved.
Okay.
Anyway, so yeah, I think there's some interest in maintaining involvement. But yeah, overall, the takeaway message here is this will increase transparency and visibility, and the commission is supportive. The 5-year provision that Riley Allen just mentioned, we haven't had a chance to really look at that. That just came to our attention this morning. So I'm going to take it to our commissioners probably on Thursday and get their take on that.
Okay.
And I could just answer questions if anyone has them, but otherwise we could move on.
Yeah, and I mean, if I'm not coming in now, except every 10 years when I have to tell me in order to get the rate flexibility that I don't have now, I have to come in every 5 years. I'm not sure would produce the results that people want, but think about, everybody think about that. Okay. Any questions for Joan at this point? Whoa, none. Okay. Thank you. So we are on to Andrea Cohen.
Good afternoon, Andrea Cohen, Vermont Electric Cooperative. I am going to try to do this in 5 minutes so you get a break, and I'm happy
That's
to come
okay.
back. Okay, all right, I appreciate that. This is a pretty short bill, but I think it'll have a very helpful impact. It can do some real good. It will really help efficiency of some process, which, good process right now is really important for efficiency. I'll just reinforce a few points that others have made. Just want to remind you, this is relevant to municipalities and co-ops. Inherent in those structures, there is a lot of transparency, a lot of democratic process, and a lot of accountability. So when we get to the part of the bill where you're talking about, does it have adequate guardrails? There's a lot of that baked in already into our governance structure. I actually think some of the guardrails that are in there are, certainly adequate. Maybe even there's too many. And you can, some of what I'll talk about is maybe giving some even more flexibility because, as said before, DPS or PUC can ask for information from us at any time. They can ask for an investigation, so if there's any concerns about anything we're doing, we're highly regulated and we pride ourselves in the transparency. So we think that, is more than adequate what's in the current bill. I'll also remind you, we don't like raising rates. So not only is the process potentially cumbersome, which some of that is appropriate, right? We're raising rates. There should be a lot of scrutiny and we shouldn't do it lightly in those circumstances. But just know we don't want to do that. So when we do bring these cases forward, or whether we avail ourselves of this process that you might support, we're only doing it after a lot of work on our part to keep our costs down and find ways to mitigate those upward cost pressures. We do have a lot of process internally before we even go to the PUC or the department with potential increases or changes. We work everything through our board of directors. In the last 10 years, VEC has had 4 rate increases. And over the last 10 years, those averaged to less than 1% a year. So if this bill passed, we would definitely see ourselves, maybe doing more frequent, which smaller efforts, which we think actually serves the members well, instead of getting hit, big in one year out of, which can really feel substantial, kind of just keeping up with those cost of living increases and things as we're going, we feel actually would serve the members well. In terms of our particular on the bill, one thing, that date that is being discussed, kind of that base date, currently it's January 1st, 21. We just went through a rate case in 2020. We had a new rate effective January 1st, 2020. So if we could take advantage of this without having to go through another one, we think that would be great. So if we could suggest, and I haven't run this by anybody else yet, but allow the process, the expedited process, if we had a new rate effective on or after January 1st, 2020. And I'll just highlight for Luke or whoever, of course, the effective date is different than the approval date. So just, clarity around that. In our case, the effective date was January 1st, 2020. So if we can make this available to us sooner by having done that, we would appreciate that. Another particular point, we weren't clear, and maybe just needs some clarity about what actually happens if an objection is raised. Is there a way to remedy that and process that and still use the expedited process? Or does it automatically kick us into a full rate case? We prefer the latter, that if an objection is raised, that there's a way to kind of work through that and then still take advantage of an expedited process. But on my simple reading, it's not clear what happens if there is an objective. What's the next step?
Okay.
And so maybe that can happen in the PUC rules, or maybe you want to do, I'm not sure where that would get clarified, maybe the rules. I think that's the main points in a nutshell. Just to close, we're very supportive. We'd be happy to work and help you get the language just how you want it. And we do appreciate VEPSA leading this and doing a lot of the legwork and carrying the water. And we just wanted to make sure we indicated our support.
Okay, I think for next time, I'm still not clear, because I haven't heard any numbers, as to why, other than I know how hard it is to raise rates at a local level. It's like raising property taxes. You do tend to avoid that. I haven't heard anything other than the fact that it's painful to raise rates, why you would avoid a hearing. So I'm looking for some time, cost, risk numbers, not for now.
Right.
And I'm also looking for that question, because if you've just got one disgruntled neighbor who doesn't want to pay anything for anything, and that can throw you into a complete, full-blown hearing, then why risk it if you can avoid it, which is the situation we've got going now. And yeah, it is much more painful. I have a friend who rents apartments, and he said, I can go up 2% a year and no one ever notices. But if I wait 5 years and go up 10%, it hurts and everyone screams. There is an argument to those small increases being easier to absorb, and also just better business practice for you. So I'm looking for middle grounds, some thought about what happens. I'm not going to get any, and also some, why are you avoiding it? I mean, I want to make sure if we're going to change the status quo, that we're going to make this better for everyone and not just make it a different system, but with all the same, it's still going to be very painful and I'm still risking a full hearing and therefore I'm not going to do it kind of thing. So I think I'll leave you all sitting with that thought. And committee, we only have a 10-minute break. And we're going back to arrearages and disconnects. And just keep your questions in mind and we will be back to this one. This was just our first walkthrough.
Madam Chair, can I
Yes.
just, when they come back, I don't know who is the right person to do this, but having a kind of flow chart visual of what the process is so we can see what it actually entails and what it may cost and who might be involved. That would be helpful to me. And it sort of gets at what you were just talking about.
Yeah, no, that would be very helpful. The chair is a visual learner. She likes charts that say A, B, C, D.
Yeah, I do too. Thank you.
Okay, thank you, committee. We're down to 9 minutes. I'll see you.